Hi friends, welcome to Telugu One Academy as part of our Polity Quick Revision. Let's today discuss the judicial system in India, the judiciary in India. See, as I told you even in the earlier classes, when compared to the classical federations in the world till then, when the Constitution of India was made in 1950, the classical federations which existed till then, in those classical federations, there is a dual judiciary. For example, if you take United States of America, which is a classical federation, which is the first federal constitution in the world, there is a dual judiciary. So the judiciary of the center is independent of the judiciary of the states. So the judicial power is divided between the federal government and the state government. That's why it is called parallel judiciary. Parallel judiciary. Unlike American Constitution, the framers of the Indian Constitution provided for in an integrated judiciary for under the Indian Constitution. And I have explained the reason. In India, we have one set of courts for enforcing both the central laws and the state laws. But under the American Constitution, the federal laws are enforced through the federal Supreme Court or the American Supreme Court, and the state laws are enforced through the state Supreme Court. But in India, we have the same set of courts for enforcing both the central and the state laws. The Indian Supreme Court can enforce not only the central laws but also the state laws. Similarly, the state high courts in that particular state can enforce both central and the state laws. And one important reason given by B.R. Ambedkar for having an integrated judiciary is to promote unity and integrity of India. So in a country with a federal constitution, there is a possibility of diversity of laws in several states in the country, and if there is a dual judiciary, it will create problems, and that there may be issues of greater coordination and cooperation. And as a result, the framers of the Indian Constitution, in their wisdom, they felt that by having an integrated judiciary for the entire country, we can greatly avoid unnecessary confusion and inconvenience in running the administration of the both central and the state governments. That's the reason why the Indian Constitution provided for an integrated judiciary. So in India, we have courts in the form of a pyramid. So we have the highest level, we have Supreme Court. Below the Supreme Court, we have 25 high courts, and below the high courts, we have lower courts. Lower courts. This is what we say integrated judiciary. So having an integrated judiciary is again a unique feature of the Indian Federal Constitution. In the Constituent Assembly, if you see the debates in the Constituent Assembly, Alladi Krishnaswamy Iyer, he said that the Supreme Court of India is the most powerful Supreme Court in the world. If you make a comparison between the Indian Supreme Court and the American Supreme Court, Supreme Court of USA, Supreme Court of India, the American Supreme Court is purely a federal court. The purpose of the American Supreme Court is to resolve the disputes among the units of the federation and also to enforce the fundamental rights guaranteed by the American Constitution and to protect and uphold the supremacy of the American Constitution. So American Supreme Court is purely a federal court. But Indian Constitution, in addition to being a federal court, it is also the highest appellate court. So the Indian Supreme Court has got a criminal, civil and a constitutional appellate jurisdiction. But the American Supreme Court has got appellate jurisdiction only with respect to constitutional matters. In addition to this, the American Supreme Court doesn't have the power of advisory jurisdiction. Advisory jurisdiction. It is absent, but here it is present. So what is advisory jurisdiction? Under the Constitution of India, under Article 143, the President of India can seek advice from the Supreme Court, which means the Supreme Court can give advice to the President of India on any matter which is referred to the Supreme Court. So this power is not given to the American Supreme Court. In addition to this, there is one article, Article 136. So Article 136 under the Indian Constitution, it deals with special leave petition. So under Article 136, the Indian Supreme Court can take before itself any case decided anywhere in the country, excepting the military courts. So the Supreme Court can intervene in any case decided by the high courts or the tribunals or the subordinate courts for doing justice to the people. Even this power is absent to the American Supreme Court. In addition to this, there is one article, Article 142. Article 142 of the Indian Supreme Court gives the power to the Indian Supreme Court to pass any order to do complete justice. Even such a power is not there on the American Supreme Court. On the American Supreme Court, when deciding the cases, the entire court sits as one court. But the Indian Supreme Court, because of the workload before itself, it forms into multiple benches: single judge bench, 2 judge bench, 3 judge bench, 5 judge, 7 judge, 9 judge, 11 judge, 13 judge. So even in India, the Indian Supreme Court has to sit as a single court, but because of the burden of the cases before itself, the Supreme Court will divide the work before itself among the judges of the Supreme Court by forming into a number of benches, groups of judges. It is called bench. And the number of cases which the American Supreme Court decides every year is very small. But if you take the Indian Supreme Court, because of its very wider jurisdiction, the number of cases decided by the Indian Supreme Court is many folds bigger than the number of courts decided by the American Supreme Court. That's why it was said that the Indian Supreme Court is the most powerful Supreme Court in the world. Then let's move to the judiciary in India. As I said just now, in India we have an integrated judiciary. At the highest level we have the Supreme Court, and below the Supreme Court we have 25 high courts, and below each high court there are a number of lower courts. So that's the organization here: Supreme Court, High Court. Below the High Court there is a district court, and below the district court we have lower courts called subordinate courts. Then we will try to spend some time on the Indian Supreme Court. See, the Supreme Court of India was inaugurated on 28th January 1950. So recently it has completed 75 years of its existence in the country. And in addition to this, initially the Supreme Court had a total of 7 judges, including the Chief Justice of India, 1 plus 6. But today we have total of 34 judges, 1 Chief Justice of India and 33 judges of the Supreme Court. Remember, the number of judges in the Indian Supreme Court can be increased by the Indian Parliament through an ordinary law. Then, what are the qualifications to become a judge of the Supreme Court? So, a person who wants to become the judge of the Supreme Court must be a citizen of India. That is the first requirement. Here there is no minimum age prescribed. The Constitution of India does not prescribe the minimum age to become the judge of the Supreme Court. The second one, a person who has served as a judge of the High Court for 5 years. A person who has served as the judge of the High Court for 5 years is again eligible to become the judge of the Supreme Court. The third one is a person who has practiced as an advocate. A person who has practiced as an advocate for the last 10 years in one high court or in more than one high court is also eligible to become the judge of the Supreme Court. In the opinion of the President of India, if a person is a distinguished jurist, then again he can become the judge of the Supreme Court. These are the qualifications which were laid down. So he must be a citizen of India. In addition to that, he must be either one of the following three. The first one, either he should be a judge of the High Court for 5 years, or he should have practiced as an advocate for 10 years in one or more courts, one or more high courts, or in the opinion of the President of India, he must be a distinguished jurist. A distinguished jurist means an expert on the constitution and the laws. These are the qualifications to become a judge of the Supreme Court. And then how the judges of the Supreme Court are appointed. Here there are three important cases which we say: first judge case, second judge case, third judge case, fourth judge case. So this first judge case, it is also called SP Gupta versus Union of India. The second judge case, it is called the Supreme Court Advocates on Record Association versus Union of India. This was in 1993. This was in 1982. The next one is Presidential Reference Case. Presidential Reference Case, this was in 1998. The fourth one is again Supreme Court Advocates on Record Association versus Union of India, 2015. See, Article 124 speaks about appointment of the judges of the Supreme Court. So in the Constitution of India, it is laid down that a judge of Supreme Court shall be appointed by the President of India by consulting the Chief Justice of India and such other judges of the Supreme Court and High Court. So if you want to appoint the judge of the Supreme Court, the President of India, who is part of the executive branch, must consult the Chief Justice of India and such other judges of the Supreme Court and High Court as he may deem necessary. That is what is laid down in the Constitution of India. In other words, if you summarize the appointment process, it is the appointment of the judges of the Supreme Court and High Court. It is a joint venture between the executive and judicial branches. So the executive branch will consult the judiciary, and if both agree, the appointment is done. If there is disagreement between the executive and judicial branches, the appointment is dropped. This was a case from 1950 to 1982. From 1950 to 1982. So from 1950 to 1982 in this country, the judges of the Supreme Court and the judges of the High Court, they are appointed by the President by consulting the judicial branch. If both executive branch and judicial branch agree, the appointment is made. If there is a disagreement, then the appointment is dropped. In other words, there was a perfect balance between the executive and judicial branches in appointing the judges of the Supreme Court and High Court. But this balance was disturbed in the first judge case. So the first judge case, it is also called SP Gupta versus Union of India. This is also called judges transfer case. So in this case was decided by a 7-judge bench. In this case, the Supreme Court said, while appointing a judge of Supreme Court, while appointing a judge of the High Court, while transferring a judge from one High Court to another High Court, after consultation between the executive and judicial branches, if there is a difference of opinion, the opinion of the executive branch will prevail over the opinion of the judicial branch. Then why the Supreme Court said so? The reasons given by the Supreme Court is, when you compare the executive branch with the judicial branch, the executive branch is more accountable compared to the judicial branch. So there should be primacy or importance to the opinion of the executive branch. This is the judgment. So in the first judge case, the word consultation in Article 124 was interpreted to mean exchange of opinion. It doesn't mean concurrence. Concurrence means the Chief Justice of India, the opinion of the Chief Justice of India is not binding. So in the first judge case, the Supreme Court interpreted that the word consultation in Article 24 does not mean concurrence. Concurrence means the opinion of the Chief Justice of India is not binding on the executive branch. There will be definitely consultation between executive and judicial branches. There will be exchange of opinion. In case there is a disagreement, then the opinion of the executive branch will prevail over the judicial branch. So the balance between the executive and judicial branches in appointing the judges of the Supreme Court was lost in this case. So from 1982 onwards, the power to appoint the judges of the Supreme Court and High Court, it went completely into the hands of the executive branch because of executive primacy given. So that's the reason why from 1982 to 1993, if you see the appointments done to the Supreme Court and High Court, the role of the Chief Justice of India was completely marginalized. So because of this experience, the matter went again before the Supreme Court in one more case, that is the second judge case. So the second judge's case, it is also called Supreme Court Advocates and Record Association versus Union of India 1993. So all the practicing advocates on record in the Supreme Court, they have filed this case. That's why it is called Supreme Court Advocates on Record Association versus Union of India. So this case was decided in 1993 by a 9-judge bench by 7:2 majority. And what is the decision? So in this case, the Supreme Court has come up with a new institution for making appointments to the Supreme Court and High Court, that is collegium. So collegium was created for the first time in this judgment, in the second judge case, So in the second judge case, the Supreme Court has interpreted the provisions of Article 124 and Article 217, which deal with the appointment of the judges of the Supreme Court and High Court in the following way. So in this case, the Supreme Court said, when there is consultation of the executive branch with the judicial branch while making appointments to Supreme Court and High Court, and while transferring judge from one High Court to another High Court, the opinion of the Chief Justice of India is binding on the executive branch. The opinion of the executive branch can be ignored. In this case, the Supreme Court has interpreted the word consultation to mean concurrence. Concurrence means the Chief Justice of India must agree. If he doesn't agree, then the views of the executive branch cannot be put in implementation. So in other words, from 1950 to 1982, both executive and judiciary had an equal role. In 1982, executive was given primacy. But in 1993, the primacy, the importance is given to the judicial branch. So it is in this second judge's case in 1993, the Supreme Court has come up with an institution called collegium. So in this case, the Supreme Court said, while appointing the judges of the Supreme Court and the High Court, while transferring a judge from one High Court to another High Court, the opinion of the Chief Justice of India in consultation with the two senior most judges of the Supreme Court will be binding on the executive branch, That is the second judge's case. So the significance of the second judge's case is creation of collegium. Later on, the government of India was in a lot of confusion. The Supreme Court in the second judge's case said about collegium. So under Article 143, the Union government through the President of India has asked the Supreme Court to give clarity on what this collegium is all about. So that's the third judge case. The third judge case was decided in 1998, again by a 9-judge bench unanimously. So in this 9-judge bench, the Supreme Court said that the appointment of the judges of the Supreme Court and the appointment of the judges of the High Court and the transfer of a judge from one High Court to another High Court, it has to be done on the recommendations of the collegium, which is binding on the President. And it is in this case, in the third judge case, the Supreme Court has given a clarification. It said that collegium, the composition of collegium was clarified in the third judge case. Collegium will contain Chief Justice of India and 4 senior most judges of the Supreme Court. So while appointing a judge of the Supreme Court, while transferring a judge from one High Court to another High Court, the decision is to be taken by collegium. And the collegium will contain the Chief Justice of India and 4 senior most judges of the Supreme Court. Remember, here in the third judge case, the Supreme Court said the opinion of the Chief Justice of India must be supported by at least 3 out of the remaining. So then the advice will be given to the President and it is binding on the President. But the President can say no once. If the President, if the union government is not happy with any name recommended by the collegium, the President can ask the collegium to reconsider the advice. But after reconsideration, if the same names are recommended to the President is bound to make appointments. He cannot say no to such appointments. But the Supreme Court in the third judge's case, it also said, while appointing a judge of the High Court, collegium will contain only 3 judges, Chief Justice of India and 2 senior-most judges of the Supreme Court. Here again, while appointing a judge of the High Court, the opinion of the Chief Justice of India must be supported by at least 1 out of the remaining 2 judges. So, if at least 1 out of the remaining 2 judges of the Supreme Court support the opinion of the Chief Justice of India, then the advice of the collegium is binding on the President. So, that is what the Supreme Court has clarified in the third judge's case. The fourth judge's case, we will discuss it later, but in the meanwhile, so we will try to discuss one controversy. See, in 1973, in 1978, something went wrong. See, the practice is, if the present Chief Justice of India retires after attaining the age of 65 years, the next senior most judge of the Supreme Court will become the next CJI. So, if the present CJI retires because of superannuation, a judge in the Indian Supreme Court who is the senior most in terms of years of service will become the next CJI. So, the principle of seniority was not followed in the year 1973. Here, A.N. Ray, who was a junior to 3 judges, Sheelat, Grover and Hegde. Sheelat, Grover and Hegde, who were senior to A.N. Ray, was not considered to the post of the Chief Justice of India. Instead, A.N. Ray, who was a junior to these 3 people, was made the Chief Justice of India. And all the 3 judges, Sheelat, Grover and Hegde, they have resigned in protest. And again it happened for the second time in 1978. This time, H.R. Khanna versus H.M. Beg. H.M. Beg. H.R. Khanna was a senior to H.M. Beg, but H.R. Khanna was not considered to the post of Chief Justice of India, and Beg was made the Chief Justice of India. Then why did this happen? The first incident happened because on 24th April 1973, we had an important judgment called Keshavananda Bharati case. Keshavananda Bharati versus State of Kerala. This was a 13-judge bench by 7:6 majority. In this case, the Supreme Court said, the power of the Indian Parliament to amend the Constitution under Article 368 is a limited power. Then what are the limitations on the amending power of the Indian Parliament? In Keshavananda Bharati case, the Supreme Court said, in the Constitution of India, there are certain features which are very important, basic and fundamental. Such provisions, the basic features of the Constitution of India cannot be amended. So this was the judgment given by these 3 people, Sheelat, Grover and Hegde. They have put a limitation on the amending power of the Indian Parliament, which the government did not like their judgment. That's why they were superseded and their junior was made the Chief Justice of India. Similarly, in 1978, we had between 1975 and 1977, we had internal emergency declared in the country by Mrs. Indira Gandhi. When the personal liberties of the people were taken away under national emergency, the matters went to the High Court and the Supreme Court. So in ADM Jabalpur case, which is famously called habeas corpus case, the Supreme Court supported the government of India, and it has upheld the suspension of the fundamental rights, including the fundamental rights guaranteed by 20 and 21. Out of the 5 judges who decided the ADM Jabalpur case, one of them was H.R. Khanna. H.R. Khanna gave a dissenting judgment. He said that the fundamental rights guaranteed by Article 20 and 21 are very important. They cannot be suspended at any point of time, even during national emergency. So the Union government again did not like this judgment. That's why H.R. Khanna was not considered for the office of the Chief Justice of India. Instead, his junior Beg was made the Chief Justice of India. So to correct such anomalies from happening again in the future, in the second judge's case, it was very clearly laid down. In the second judge's case, it was very clearly laid down that from now onwards, so I told the second judge's case was delivered in 1993. So from 1993 onwards, only a senior most judge of the Supreme Court will become the next CJI. So which means, so the opportunity for the executive branch to interfere was taken away by the second judge case. This is again one important thing. Then in India, from 1993 till today, we have the system of collegium in place. And I told you what is collegium. See, the system of collegium is very much criticized because India is the only democracy in the world where judges appoint judges. In no other democracy you see this. For example, if you take United States of America, the judges of the American Supreme Court are appointed by the American President, the executive branch, and confirmed by the American Senate, which is the part of the legislative branch. But in India, the judges are appointed by judges through the collegium. The advice of the collegium is binding on the President. So if you, after having seen the working of collegium for a very long time, it was felt that the decisions made by the collegium, they are not transparent. There was no objective criteria in appointing the judges of the Supreme Court and High Court. So there was a lot of opacity in the working of the collegium. Many a times, many judges who are deemed to be meritorious and who are also honest, they are not elevated to the Supreme Court as the judge of the Supreme Court. Many a times the considerations of region, caste, family connections, they play an important role in appointing the judges of the High Court and Supreme Court. So people from within the judiciary, like people like Justice M.N. Venkatachalaya, Justice J.S. Verma, Justice Ravindran, many people like that, they criticized the system of collegium. So the system of collegium lacked transparency in its working, and as a result the quality of appointments under the collegium has come down. So because of this problem with the collegium, in 2015, an attempt was made to replace the system of collegium with a new body called NJAC, National Judicial Appointments Commission. So this NJAC was brought in through 99th Constitutional Amendment Act. 99th Constitutional Amendment Act of 2014. So the Indian Parliament, by a special majority, a majority of the total membership and 2/3 of the members present and voting, and half of the states, they have agreed for this amendment. And this amendment, along with an ordinary law, NJAC Act 2014, they were challenged before the Supreme Court. Before we discuss what the Supreme Court had said in this case, what is the composition of this NJAC? And even before this, what are the articles inserted through the 99th Amendment? 124A, 124B, 124C. So through the 99th Amendment to the Indian Constitution, three new articles are inserted in the Indian Constitution: 124A, 124B, 124C. So 124A of the Indian Constitution, it provided for the establishment of NJAC. 124B, it speaks about the functions of the NJAC. So NJAC will appoint the judges of the Supreme Court and High Court. It will transfer the judges from one High Court to another High Court, which means what the collegium was doing till now will be done by the NJAC. And Article 124C authorized the Indian Parliament to make an ordinary law to prescribe the procedure for the working of the NJAC. So NJAC has contained Chief Justice of India, 2 judges of the Supreme Court, law minister, and 2 members from the civil society. This is the composition. So NJAC has a total of 6 members. a Chief Justice of India, 2 senior most judges of the Supreme Court, 1 law minister, 2 members representing the civil society. If an appointment is to be done to the Supreme Court and High Court, if a judge has to be transferred from one High Court to another High Court, the decision has to be taken by at least 5 out of the 6 people. Even if 2 people say no, then the appointment and transfer cannot be done. So there was a perfect check and balance. 3 members are from judiciary, 3 are from non-judiciary. So the opinion of the 3 members from the judiciary is not binding. The opinion of the 3 non-judicial members is also not binding. If any appointment is to be done, if a transfer has to be done, the judicial and non-judicial members must come together. Out of 6 members, at least 5 shall agree for confirming the appointment or for confirming the transfer. And this 99th Amendment and the NJSC Act 2014 was challenged before the Supreme Court. And in a case known as a 4th judge case, in a case known as 4th judge case in 2015, a 5-judge bench by 4:1 majority has struck down the 99th Amendment as invalid. This is for the first time an entire amendment of the Indian Constitution by the Parliament was totally struck down as invalid. The reasons given by the Supreme Court is, while appointing the judges of the Supreme Court and High Court in the proposed NJSC, the judicial branch doesn't have supremacy, it doesn't have primacy. And the Supreme Court said, primacy of the judiciary in making appointments to the Supreme Court and High Court in the NJSC is a basic feature of the Indian Constitution. So the Supreme Court said, in the appointments to higher judiciary, judiciary shall have primacy, judiciary shall have supremacy. But in the NJSC, out of 6 member judges are only 3 members, and out of 6 at least 5 should agree. So in the NJSC composition, the judges don't have primacy. And the Supreme Court said, primacy of the judiciary in making appointments and transfers itself is a basic feature. So as the basic feature is violated, the 99th Amendment is constitutionally invalid and the NJSC was struck down as invalid. So because of striking down of 99th Amendment and NJSC Act, the system of collegium got revived. But here we should remember, one of the judges, Justice Chalameshwar, gave a dissenting judgment. In other words, Justice Chalameshwar said the 99th Amendment is constitutionally valid, and in addition to that, he also said that the NJSC Act 2014 is also constitutionally valid. But you know that minority judgment will not prevail, it is only the majority judgment which will prevail. So that's the controversy with respect to appointing the judges of the Supreme Court and High Court. So I told you about the first judge case, second judge case, third judge case, the 99th Amendment, NJSC Act 2014, the working of collegium. That's about the appointments. As of now in India, a judge of Supreme Court is appointed by the President on the advice of the collegium. Collegium will contain the Chief Justice of India and 4 senior most judges of the Supreme Court. So the opinion of the Chief Justice of India must be supported by 3 out of the remaining 4 members. Similarly, if you want to transfer a judge from one High Court to another High Court, again the opinion of the Chief Justice of India must be supported by 3 out of the remaining 4. But if you while appointing a judge of the High Court, the opinion of the Chief Justice of India must be supported by 1 out of the remaining 2 judges. I said while appointing a judge of the High Court, collegium will contain only 3 judges. And in the Constitution of India, it is laid down. If you want, when you appoint a judge of the High Court, the President of India has to consult the Chief Justice of India and the Governor of the concerned state and also the Chief Justice of the concerned state. That is what is laid down. So this is something with respect to appointments. Then once after a judge has been appointed, the judge will remain in office. If you are a judge of the Supreme Court, the judge will remain in office till the age of 65 years. Till the age of 65 years. So he was given security of tenure. Remember, under the Constitution of India, the Indian Supreme Court is called the guardian of the Indian Constitution. It is the protector of the Indian Constitution. It is the final interpreter of the Indian Constitution. So if the Indian Supreme Court and the High Courts, if they have to protect the Constitution of India and uphold the supremacy of the Constitution, they must enjoy independence. That is called judicial independence. Judicial independence. Then how this independence of the judiciary is guaranteed? The independence of judiciary is guaranteed by a number of provisions. The first one is security of tenure. A judge of Supreme Court and a judge of High Court, they have the security of tenure, which means if you want to remove a judge of High Court and Supreme Court, if you want to remove a judge of Supreme Court and High Court, it's very difficult to remove them because it was laid down in the Constitution that they can be removed on two grounds. One is proved misbehavior. The other one is incapacity. Proved misbehavior and incapacity. So these are the two grounds which were laid down in the Constitution of India. If you want to remove the judge of the Supreme Court and the judge of the High Court, the grounds are proved misbehavior and incapacity. And if there is any allegation of corruption against any judge of the Supreme Court and High Court, if it is in the Lok Sabha, 100 members of the Lok Sabha, or if it is in Rajya Sabha, 50 members of the Lok Sabha, they should sign a petition and give it to the Speaker of the Lok Sabha or the Chairman of the Rajya Sabha. And this is laid down in Judges Inquiry Act 1968. Judges Inquiry Act 1968. So Judges Inquiry Act 1968, which was made by the Parliament, so this law says that 100 members of the Lok Sabha or 50 members of Rajya Sabha, they should sign a petition for the removal of a judge and submit this petition to the Speaker or the Chairman. The Speaker of Lok Sabha or the Chairman of Rajya Sabha can either admit the petition or can reject the petition. If the petition is admitted, then the Speaker or the Chairman will appoint a 3-member committee. And in the 3-member committee, there will be one Chief Justice of India or Judge of the Supreme Court, one Chief Justice of one of the High Courts, and a distinguished jurist. So this 3-member committee will look into the allegations of the concerned judge, whether he may be a judge of Supreme Court or High Court. And if the allegations are proved, then the removal of the judge of Supreme Court or High Court is taken up in Lok Sabha and Rajya Sabha. Both in Lok Sabha and Rajya Sabha, the removal motion has to be passed by special majority. A majority of the total membership and 2/3 of the members present and voting shall agree for the removal motion. And if the removal motion is passed in Lok Sabha and Rajya Sabha by this special majority, then the President can remove the judge of Supreme Court or the judge of the High Court. So far, in the last 75 years, not even a single judge has been removed through this process, because this process has proved to be very difficult, and as a result, no judge has been removed till now. But the first judge who faced the removal proceedings are Justice Ramaswamy. After Justice Ramaswamy, we have Justice Soumitra Sen, we have Justice P.D. Dinakaran, we have Justice C.V. Nagarjun Reddy, etc. In other words, there were around more than 7 to 8 attempts made to remove the judges of the Supreme Court and High Court by this method, but none of them proved to be successful. So that's how the judges of the Supreme Court and High Court can be removed. So a difficult removal will give you the necessary independence for the judiciary, and because of security of tenure, the judges of the Supreme Court and High Court can remain impartial and independent. And the other provisions which will guarantee independence is the conduct of the judge of the High Court or the Supreme Court cannot be discussed in the Parliament or the state legislature. In the Parliament, it can be discussed only in the event of removal of the judge, but otherwise the conduct or the behavior of the judges of the Supreme Court and High Court cannot be discussed in the Parliament or the state legislature. In addition to that, the salaries and allowances of the Supreme Court judges and High Court judges, they are charged on the Consolidated Fund of India, which means Parliament cannot reduce this. In addition to this, the Supreme Court and High Court can choose its staff without depending on the executive branch. In addition to this, the judges of the Supreme Court are not allowed to practice anywhere in the country, and this will also ensure independence of the Supreme Court. If it is a judge of the High Court, he can practice in other High Courts and the Supreme Court, but not in the same High Court. All these, they guarantee the independence of judiciary. Discussion on judiciary in India. So in the recent past, if you remember, Justice Yashwant Verma, who served as the judge of the Delhi High Court, in his house at his residence, burnt cash was discovered. So in the context of this particular issue, there was something in the news which is called in-house committee. See, to investigate the corruption charges of a judge of Supreme Court or High Court, there are two methods. One is the Speaker of the Lok Sabha or the Chairman of the Rajya Sabha on a petition by the members of Lok Sabha or Rajya Sabha can appoint a 3-member committee. That is different. That 3-member committee had a Chief Justice or Judge of the Supreme Court, one Chief Justice of the High Court and a distinguished jurist. In addition to this method, the Supreme Court itself has come up with an in-house procedure. This was done in 1999 in one of the cases, Ravichandran Iyer versus Bhattacharjee, S.K. Bhattacharjee. This is the case in which the Indian Supreme Court, this is the case which led to coming up with the in-house procedure for investigating the complaints against the judges of the High Court and Supreme Court. So Ravichandran Iyer versus S.K. Bhattacharjee. So after this judgment, a 5-member committee was appointed consisting of the judges of the Supreme Court and High Court. On the basis of the report of the 5-member committee, in 1999, the in-house procedure was finalized. So if there are charges of corruption against any judge of the High Court, the concerned Chief Justice of India will give a report whether to make a further deeper probe. If the Chief Justice of the concerned High Court is of the opinion that the investigation of the judge needs a deeper probe, then the Chief Justice of India can appoint a 3-member committee. So this 3-member committee will contain 2 Chief Justices of the High Court and 1 Judge of the High Court. That is the composition. So on the report given by the 3-member committee, if there are allegations are found to be true, the Chief Justice of India will ask the concerned judge to resign or to take compulsory voluntary retirement. If the judge does not comply with this recommendation, then the judicial work will be withheld from the concerned judge. And he can also recommend to the Prime Minister and the President of India to initiate the removal proceedings. But the problem with the in-house procedure is there were around 7 such committees which were appointed. Only in 2 instances the report of the in-house committee has come into the public domain. And here in the working of the in-house committee, again there is opacity. The in-house committees, they take a long time to give the report, and what is the progress of the investigation, that never comes into the public domain. So in this context, something has been in the news. JSAB, it is called a JSAB, Judicial Standards and Accountability Bill. So this was one bill which has come before the Indian Parliament in 2010, Judicial Standards and Accountability 2010. So in 1997, the judiciary has come up with the judicial standards which is called a restatement of values in judicial life. So the judicial standards and accountability bill wanted to give legal backing to the judicial standards agreed upon by the Supreme Court and the High Courts in 1997. So this judicial standards and accountability bill also provided for National Judicial Oversight Committee consisting of Chief Justice of India, a Judge of the Supreme Court, Chief Justice of the High Court, Attorney General of India, and one nominee of the President. So under the National Judicial Oversight Committee, there will be a complaints scrutiny panel, and under the complaints scrutiny panel, there will be an investigation committee. This is the proposed mechanism under the Judicial Standards and Accountability Bill. So this bill could not become a law and the bill got lapsed. So now the question before us is whether to bring back NJSC or the National Judicial Standards and Accountability Bill in dealing with the corruption in the judiciary. Some say that we need to bring back NJSC, some say we need to bring back Judicial Standards and Accountability Bill. But the former Attorney General of India, K.K. Venugopal, he wanted the judgment of the Supreme Court in the 4th judge case decided by the 5-judge bench to be referred to a bigger bench. So if a bigger bench considers the 99th Amendment, and if it can declare NJSC as constitutionally valid, then NJSC can take over the functions of the coalition. So this may ensure the right people getting appointed as the judges of the Supreme Court and High Court. Remember, in India, which is a democracy, if the executive fails, if the legislature fails, at least judiciary should not fail. Because if we need the people of highest ability and integrity to become the judges of the Supreme Court and High Court. So if the judiciary is independent and able and with people of high integrity, it can protect the Indian democracy. That's the reason why we need the people of highest ability and integrity to become the judges of the Supreme Court and High Court. So this standard is not being met by collegium. So we wanted to replace the system of collegium with NJSC. So that we need to see whether this will happen in the future or not. And let's move to the powers of the Supreme Court. So jurisdiction of the Supreme Court can be broadly classified into original jurisdiction, appellate jurisdiction, advisory jurisdiction, writ jurisdiction, and special powers. Let's take up one by one. The first one is original jurisdiction. In this, the one article is Article 131. What do you mean by original jurisdiction of the Supreme Court? If a case can go straight away before the Supreme Court in the first instance, it is called original jurisdiction. So there are certain categories of the cases which can go directly before the Supreme Court. So such a power of the Indian Supreme Court to take the cases in the very first instance, it is called original jurisdiction. In that, the first one is Article 131. For example, I said that Indian Constitution is federal. So in India, there is a possibility of a dispute between the center and the states, between a state and a state. All such disputes can directly go before the Supreme Court. The High Courts do not have the power to deal with the federal disputes. This is one original jurisdiction of the Indian Supreme Court. But under Article 131, the original jurisdiction has got certain exceptions. For example, if there is a pre-constitutional agreement, to give an example, Kaveri, sharing of waters of river Kaveri between Karnataka and Tamil Nadu was based on an agreement arrived at before India's independence. That is called a pre-constitutional agreement. So the Supreme Court of India does not have original jurisdiction with respect to a pre-constitutional agreement. In addition to that, even with respect to interstate river water disputes, the Supreme Court of India does not have original jurisdiction. In India, the interstate river water disputes are decided by tribunals, interstate river water disputes tribunals. So a decision given by the tribunal, if it is not implemented by any state, then you can go to the Supreme Court. But the Supreme Court will not resolve the interstate river water disputes by itself. That's again an exception for the original jurisdiction. In addition to this, the matters of the Finance Commission of India cannot again be taken before the Supreme Court. So this is one example for original jurisdiction, solving the federal disputes. The second one is, if there is any dispute with respect to election of the president or the election of the vice president, the matter is decided by the Indian Supreme Court. So all election disputes with respect to the election of the president and the election of the vice president can be decided only by the Indian Supreme Court. That's again original jurisdiction. In addition to this, we have one article, Article 139A. Article 139A. Article 139A says, a case from one high court to another high court can be transferred only by the Supreme Court, only through the Supreme Court. This is again the original jurisdiction of the Supreme Court. So that's about the original jurisdiction. The second one is writ jurisdiction of the Supreme Court. This was dealt by Article 32. We all know that the Constitution of India guarantees a set of written fundamental rights to all the citizens of the country. Some of these rights are available even to the non-citizens. So if these fundamental rights guaranteed by Part 3 of the Indian Constitution are not implemented, then they don't have a meaning. So that's why Dr. B.R. Ambedkar said Article 32 is the heart and soul of the Indian Constitution, because it is through Article 32 the fundamental rights get enforced through the Supreme Court of India. So Article 32 itself is a fundamental right. Article 32 speaks about constitutional remedies. So there are 5 kinds of writs. Writs are nothing but orders made by the Indian Supreme Court and the High Courts for enforcing a fundamental right. And there are 5 writs: habeas corpus, mandamus, quo warranto, prohibition, and certiorari. So all these writs can be issued by the Indian Supreme Court under Article 32. That's about the writ jurisdiction of the Indian Supreme Court. In addition to that, we also have appellate jurisdiction. This is again divided into 3 categories: civil, criminal, and constitutional. So civil cases which were decided below the Supreme Court, they can go on appeal before the Supreme Court. That is called civil appellate jurisdiction. Similarly, a category of criminal cases dealing with the death penalty, life imprisonment, 10 years of imprisonment, if these cases once decided by the High Court, they can again go before the Supreme Court. That is called a criminal appellate jurisdiction. Then some of the cases called constitutional cases relating to the interpretation of the provisions of the Indian Constitution decided by the High Courts, they can also go on appeal before the Supreme Court. That is called constitutional appellate jurisdiction. So the Indian Supreme Court, apart from being a federal court, it is also the highest court of appeal. So in civil matters, criminal matters, constitutional matters, the cases decided by the High Court can go on appeal before the Supreme Court. That is called appellate jurisdiction. In addition to this, as I said just before, there is one article, Article 136. It deals with the SLP, special leave petition. SLP means a petition which is filed before the Supreme Court with a special leave of the Supreme Court. Special leave means special permission of the Supreme Court. So this is an extraordinary power, because by using Article 136, the Supreme Court can intervene in any case decided anywhere in the country by a lower court or by a high court or by a tribunal. This extraordinary power was given to the Supreme Court to do justice to the people of this country. So this being an extraordinary power, it has to be used very sparingly. So under Article 136, by filing a petition before the Supreme Court, any matter pending with any court can be taken before the Supreme Court, and unless the Supreme Court gives permission, the case cannot be admitted. So it is not a right of the citizen, it is the discretion of the Supreme Court. The Supreme Court will apply its wisdom, and if it feels that the case is fit enough to be taken up, then it will admit the case. Then it will decide the case. That is called 136, Article 136, special leave petition. So Article 136 is an extraordinary power of the Indian Supreme Court, and it allows the Supreme Court to take up any case in the country before itself. And this is one reason why the Supreme Court in India has become a overburdened institution. In countries like United States of America, the American Supreme Court has got a few functions. It is the federal court, it implements the fundamental rights, it enforces the federal laws, it protects the Constitution of America. That's it. But in India, in addition to being a federal court, in addition to enforcing fundamental rights, in addition to being the final interpreter and protector of the Indian Constitution, the Supreme Court can take before itself any case. So all categories of cases, civil, criminal, constitutional, family, labor, they can go before the Supreme Court. And because of this, today there is a huge burden on the Supreme Court of India. Why such an extraordinary power is given to the Supreme Court? As a matter of abundant caution, the framers of the Indian Constitution wanted to provide a remedy to the citizen of this country, if injustice is done to him at any level for any reason, they have opened the doors of the Supreme Court to intervene and to do justice for the citizen. Then the next one is Article 142. Like Article 136, Article 142 also is an extraordinary power with the Indian Supreme Court. So under Article 142, the Supreme Court can give any judgment on any issue for doing complete justice. So for doing complete justice, the Supreme Court can intervene in any matter and can pass an order for doing complete justice. This is again an extraordinary power of the Indian Supreme Court to do justice for the citizens of this country. This is again a special power of the Supreme Court. The next one is Article 143. This is also called advisory jurisdiction. So advisory jurisdiction of the Indian Supreme Court says that the President of India can refer any matter to the Supreme Court for its opinion. Here there are two things. If it is a pre-constitutional treaty, on a pre-constitutional treaty, if the President of India asks the advice of the Supreme Court, then the Supreme Court is bound to give the advice. It cannot say no. In all other matters, it is not compulsory for the Supreme Court to give it advice. It can give the advice or it can reject giving the advice. But in both of these two cases, the opinion given by the Supreme Court is not an order, is not a decree. So it is not binding on the President. So the President is not bound to follow the advice given by the Supreme Court. So I am trying to repeat, under Article 143, if the President asks the Supreme Court of India to give advice on a pre-constitutional treaty, then it is compulsory for the President to give his advice. Then it is compulsory for the Supreme Court of India to give its advice. It cannot say no. But if it is a matter other than the pre-constitutional treaty, the Supreme Court is not bound to give the advice. It can either give the advice or it can reject giving the advice. But in both of these two cases, the advice given by the Supreme Court of India is not binding on the President of India because the advice doesn't amount to an order of the Supreme Court. That's about Article 143, which is advisory jurisdiction. In addition to this, the Supreme Court of India is also called Court of Record. Court of Record. Court of Record means the Supreme Court has the power to punish for its contempt. What do you mean by contempt? If a judgment given by the Supreme Court is not enforced by any person in the country, then that amounts to contempt. Then he can be punished. So the word contempt is not defined in the Constitution of India, but it was defined in the Contempt of Courts Act 1971. So there was a law made by the Indian Parliament conferring the power of contempt on the Supreme Court and the High Court. This law was made on the recommendations of H.N. Sanyal Committee. H.N. Sanyal Committee. So as of now in India, the Supreme Court has got the power of the contempt, High Courts have got the power of the contempt, tribunals also have got the power of contempt. So if any judgment given by the Supreme Court or the High Court or the tribunal is not followed, then that amounts to civil contempt. And if the judgment given by the Supreme Court or the High Court or the tribunal is criticized, resulting in lowering the dignity of the court, then that is a punishable offence. That amounts to criminal contempt. And all these were dealt by Contempt of Courts Act 1971. That's about Court of Record. The next one is the power of judicial review. The Supreme Court has the power of judicial review. So the actions of the executive branch, the actions of the legislative branch can be subjected to scrutiny of the Supreme Court. That's what we say judicial review. It's not only that, the Supreme Court can review its own judgments, which means the Supreme Court can alter the judgments given by it but by bigger benches. So in India there is something called a constitution bench. A bench which consists of a minimum of 5 judges is called a constitution bench. If there is any case which involves interpreting the provisions of the Indian Constitution, such a case can be decided only by a constitution bench. A judgment given by a smaller bench can be overcome by a bigger bench. So the Supreme Court of India can review its own judgments and can alter these judgments. And that's why there are petitions called review petitions. Review petition. There is also called a curative petition. A review petition it is mentioned in the Constitution of India itself. So review petition, it refers to a petition filed before the Supreme Court asking the Supreme Court to review its own judgment. But a curative petition, it is not mentioned in the Constitution, it is evaluated by the Supreme Court of India. If there is gross miscarriage of justice, if the principles of natural justice are violated, if the judge is inherently biased, on all these grounds, you can file curative petition. So curative petition is the final option for the citizen. So review petition, it goes to the same bench which decided the case, but if it is a curative petition, it goes to a different bench. So these are the remedies which are available before the citizen of the country. So these are the exhaustive powers of the Indian Supreme Court. So then let's move to high courts. So in India we have 25 high courts. As I said, the Constitution of India provides for an integrated judiciary. At the highest level we have the Supreme Court, and below the Supreme Court we have 25 high courts. Some of them are having common jurisdiction. Let's see that. If you take Allahabad High Court, it was established in 1866. It has a jurisdiction over Uttar Pradesh. Remember, Uttar Pradesh, the capital of Uttar Pradesh is Lucknow. But you don't have High Court in Lucknow, it is in Prayagraj, and it has a bench at Lucknow. So there are some states where the High Court is not located in the capital of the state. One of them is Allahabad High Court. And Andhra Pradesh High Court is the most recent High Court which was established in 2019, January 1st. So the jurisdiction of Andhra Pradesh High Court is Andhra Pradesh. The seat of the High Court is at Amaravati. The next one is Bombay High Court. Bombay High Court is one of the oldest high courts, created in 1862, and the jurisdiction of the Bombay High Court extends over Maharashtra, Goa, so two states. Bombay High Court has got jurisdiction over the state of Maharashtra and state of Goa. In addition to this, Dadra and Nagar Haveli and Daman and Diu, the union territory of Dadra and Nagar Haveli, Daman and Diu will also come under Bombay High Court. So Bombay High Court deals with two states and one union territory. The 7th Constitutional Amendment Act of 1956 allowed for one High Court to be set up for more than one state. Then the seat of Bombay High Court is Mumbai, but remember, it has benches at Aurangabad, Nagpur, Panaji. The next one is Calcutta High Court. This was again one of the oldest High Court. The jurisdiction of the Calcutta High Court is Andaman and Nicobar Islands, one union territory, and West Bengal. The seat of Calcutta High Court is in Kolkata, but there are benches at Port Blair and Jalpaiguri. The next one is Chhattisgarh High Court. The capital of Chhattisgarh is Raipur, but the High Court is not located in Raipur, but instead it is located in Bilaspur. Delhi High Court, initially Delhi is the only union territory to have a High Court, but now after Jammu and Kashmir was converted from a state into union territory, along with Delhi, Jammu and Kashmir is also a union territory now. So there are two union territories with high courts. One is Delhi, the other one is Jammu and Kashmir. Then Guwahati High Court, it has jurisdiction over the states of Arunachal Pradesh, Assam, Mizoram and Nagaland. The capital of Assam is Dispur. But the High Court is not located in Dispur, it is located in Guwahati. And it has branches at Aizawl, Itanagar and Kohima. The next one is Gujarat High Court. Gujarat High Court is located in Ahmedabad, not in Gandhinagar. The capital of Gujarat is Gandhinagar, but the High Court is not located in Gandhinagar, it is located in Ahmedabad. The next one is Himachal Pradesh. The High Court is located in Shimla, the capital city. And the High Court of Jammu and Kashmir had jurisdiction over two union territories, Jammu and Kashmir and Ladakh. Again, Jharkhand has a High Court with its seat at Ranchi. Karnataka High Court, it is located in Bengaluru, but there are two benches. One is in Dharwad, the other was in Kalaburagi. Kerala High Court, though the capital of Kerala is at Trivandrum, the seat is located in Kochi. And Kerala High Court is a common High Court for Kerala as well as the Union Territory of Lakshadweep. The next one is Madhya Pradesh. Though the capital of Madhya Pradesh is Bhopal, the High Court is not located in Bhopal, it is located in Jabalpur, but there are two benches, one in Gwalior, the other one in Indore. Madras High Court is a common High Court for Puducherry and Tamil Nadu. The seat is located in Chennai, but there is a bench in Madurai. Manipur High Court, the seat is located in Impal. Meghalaya High Court, it is located in Shillong. Orissa High Court, though the capital of Odisha High Court is located in Cuttack. Though the capital is Bhubaneswar, High Court is not located in Bhubaneswar, it is located in Cuttack. Then Patna High Court, the seat is in Patna. Punjab and Haryana High Court is again a common High Court. So it is common for Punjab, Haryana and also the Chandigarh, which is a union territory. Rajasthan High Court is not located in Jaipur, which is the capital city, but instead is located in Jodhpur and it has a bench in Jaipur. Sikkim High Court, it is located in the capital Gangtok. Telangana High Court is located in Hyderabad, which is the capital city. Tripura High Court is located again in capital Agartala. Uttarakhand, when it comes to Uttarakhand, the High Court is not located in the capital. The capital of Uttarakhand is Dehradun, but the High Court is located in Nainital. That's about the information about the High Courts. Then let's see the important details with respect to the High Court. As I said, there are 25 High Courts. Initially in the Constitution of India, it was laid down that there will be one High Court for one state. But the 7th Constitutional Amendment Act of 1956 provided for establishment of one High Court for 2 or more states or more than one state and a union territory. Then when it comes to the qualifications to become a judge of the High Court, the following are the qualifications. You must be a citizen of India. You must have served in the judicial administration for at least 10 years below the High Court, or you must have practiced as a High Court advocate for at least 10 years. So here you see one of the qualification to become a Supreme Court judge, that is a distinguished jurist can become a Supreme Court judge. But a distinguished jurist cannot become a High Court judge because that qualification is not laid down. So if you want to become a High Court judge, you must be a citizen of India. You must have held a judicial office for at least 10 years below the High Court, or you must have practiced as an advocate for 10 years in one or more High Courts. That's about the qualifications. Then how the judges of the High Court are appointed. As I said initially, before the system of collegium has come, a judge of High Court is appointed by the President of India, consulting the Chief Justice of India, the Chief Justice of the concerned state and also the Governor of the state. But in 1993, the Supreme Court has come up with the system of collegium, and this was finally interpreted in 1998, the composition of collegium. Today, a judge of High Court shall be appointed by the President by consulting the collegium, and the collegium will contain 3 judges, the Chief Justice of India and the 2 senior-most judges of the Supreme Court. The opinion of the Chief Justice of India must be supported by at least 1 out of the remaining 2 judges in the collegium. Then only this is binding on the President of India. That's how a judge of High Court is appointed. Of course, the Governor is consulted, the Chief Justice of the concerned High Court is consulted, the Chief Justice of India is also consulted. Then when it comes to the autonomy of the High Courts, as I said, a High Court judge enjoys security of tenure. So he cannot be removed till he completes the age of 62 years. Within 62 years, if you want to remove the judge of the High Court, he can be removed on the grounds of proved misbehavior and incapacity. So even for this, 100 members of the Lok Sabha or 50 members of Rajya Sabha shall sign a petition, and it should be given to the Speaker or the Chairman of Rajya Sabha, Speaker of Lok Sabha or the Chairman of the Rajya Sabha. If the petition is accepted, then the Speaker of the Lok Sabha or the Chairman of Rajya Sabha will appoint a 3-member committee. This 3-member committee will include the Chief Justice of India or a judge of the Supreme Court, Chief Justice of the High Court and a distinguished jurist. So this 3-member committee will look into the allegations. If the allegations are proved, the removal is taken up by Parliament. In the Lok Sabha and in the Rajya Sabha, the removal motion must be passed by special majority, a majority of the total membership and 2/3 of the members present and voting. So with this majority, if the removal motion is passed both in Lok Sabha and Rajya Sabha, then the president can finally remove the judge of the High Court. So that's the removal. Then how the independence of High Court is guaranteed? One is difficult removal. The other one is the conduct of the judge of the High Court cannot be discussed in the parliament or the state legislature. The only exception is when the removal motion is discussed in the parliament. Then the other reasons are, a judge of High Court after retirement cannot practice in the same High Court. He can practice in the Supreme Court, he can practice in the other High Courts. The other one is, the salaries and allowances of the High Court judges they are determined by Parliament, and they are charged on the consolidated fund of the concerned states. So which means that is not subjected to the vote of the state legislature. The pension of the High Court judge is charged on the consolidated fund of India. Salary is charged on the consolidated fund of the concerned state. So the salary and allowances cannot be varied to his disadvantage while he is in office. So these are some of the measures which were taken for ensuring the autonomy of High Courts. Even the staff of the High Court can be recruited by the same High Court without any dependence on the executive branch. Then let's move to the powers of the High Court. So if you take the powers of the High Court are not clearly laid down in the Constitution of India. So it was said that the High Courts will enjoy all those powers which were there to them at the time of commencement of the Indian Constitution. And broadly, the powers of the High Court are the following. The first one is, the High Court has got original jurisdiction in certain matters. Original means a case can directly go before the High Court. So any disqualification petition with respect to a member of Parliament or a member of the state legislature can directly go before the High Court. In certain civil and criminal matters, it also has got original jurisdiction. That's about the original jurisdiction. The next one is writ jurisdiction. Article 226 of the Indian Constitution empowers the High Court to issue writs for the enforcement of fundamental rights. I just told you a writ is an order given by the High Court or the Supreme Court for enforcement of a fundamental right. And there are 5 writs: habeas corpus, mandamus, quo warranto, prohibition and certiorari. Remember, the High Court, the writ jurisdiction of the High Court is wider than that of the Supreme Court. A High Court can issue writs not only for the enforcement of the fundamental rights, it can also issue writs for the enforcement of other legal rights. But the Supreme Court can issue writs only for the enforcement of the fundamental rights. In this issue, the writ jurisdiction of the High Court is wider than that of the Supreme Court. Then the next one is, the High Court has got administrative control over the courts below it. So the appointment, promotion and transfer of the High Court judges is done by the High Court itself. And below the district judge, you have lower courts. The appointment of these judges is done by the State Public Service Commission in consultation with the High Court. So that's dealt by Article 233 and 234. So a High Court will have superintendence and control over all the courts below it, including the tribunals. So every High Court will exercise both the judicial control and administrative control over the courts below it, including the tribunals. And again, High Court is a court of record. So which means if a judgment given by the High Court is willfully disobeyed, that amounts to the contempt of the High Court. So there is both civil contempt and a criminal contempt. And this was defined in Contempt of Courts Act 1971, which I have already told. So that's about the concept of court of record. And the High Court also enjoys the power of judicial review. So it is also part of the higher judiciary. The High Court also has the responsibility to uphold the Constitution. The judges of the Supreme Court and High Court, when they take oath, they say that they will bear true faith and allegiance, loyalty to the Constitution of India, protect the unity and integrity of India, uphold Constitution and laws. That's the oath which the judge of Supreme Court and High Court will take. So that's why they have a duty to protect and uphold the Constitution and the laws in this country. So as I said earlier, the High Court in that particular state can enforce not only the state laws but also the central laws. On the other hand, the Supreme Court can enforce the central laws and also the state laws in the entire country. So that's why we say integrated judiciary. So that's it about the powers of the High Court. So we are done with the powers of the High Court. Then we have subordinate courts. See here, if you see this table, the courts at the district level, we have the courts below the High Court, they are again at two levels. The lower courts below the High Court, they are at two levels, at the district level and below the district. At the district level, we have a civil court, that is called, the judge of the civil court is called district judge or subordinate judge. And there is a criminal court and also revenue court. So these are three categories of courts at the district level: civil court, criminal court, revenue court. See, criminal court, it is also called as sessions court. Sessions court. So civil matters are decided by the district court, criminal matters are decided by the sessions court, and the revenue matters are decided by the revenue courts. And there will be an appeal to the High Court from all these courts: civil court at the district level, sessions court at the district level, revenue court at the district level. And below the district level, we have other smaller courts. They vary from state to state. Then let's discuss, before we discuss Lok Adalats, let's discuss All India Judicial Service. So recently on the Constitution Day, the present President of India, Draupadi Murmu, called for establishment of All India Judicial Service. Even the then Chief Justice of India, Justice D.Y. Chandrachud, also argued for establishment of an All India Judicial Service. So what is the problem with the judiciary at the district level? As of now, in India, there is no uniformity in appointing the judges of the lower courts. Many a times the appointments are done on ad hoc basis. At any given point of time, there are a huge number of vacancies. And even the transparency in the appointment process is also not much. And in addition to this, the quality of the judges who are being appointed under the existing system is poor. So in this context, from time to time, the Law Commission of India, judgments of the Indian Supreme Court, individuals like the ex-CJI, they are all advocating for establishment of an All India Judicial Service. In India, we have All India services like the Indian Administrative Service, Indian Police Service, Indian Forest Service. We all know that All India service officers are recruited through UPSC through an All India competitive examination. Because of centralized recruitment, we have the best and the brightest people chosen to All India services. These All India service officers, they man all important positions at the level of union government and even at the level of state government. They play an important role in maintaining the standards of administration. On the same lines, if the judges at the district level are recruited through an All India competitive examination, then the best and the brightest among the law graduates will be chosen for the lower judiciary. This will improve the quality of delivery of justice at the lower level. In India, there is a huge pendency of cases and there is a lot of delay in deciding the cases. This puts an enormous burden on the people of this country, especially the poor. So if you want to improve the speed and efficiency of the judiciary, especially at the lower level, we need to improve the quality of judges at the lower level. We need to increase the efficiency of the working of the judges at the lower level. So there was a strong belief that by going in for establishment of an All India Judicial Service, by having centralized recruitment, the best and the brightest can be encouraged to join the judiciary at the lower level. But even if All India Judicial Service is established, there are certain problems. If not addressed, even All India Judicial Service will not be a solution for the problem. Because the pay for the judges at the lower level is very low, the conditions of service are not encouraging, the career advancement is also not good. So even after creating an All India Judicial Service, we need to improve the pay, we need to improve the conditions of service, we need to provide a better career advancement. If this is done, then only the establishment of All India Judicial Service will be useful. And as pointed out by the Law Minister of the Union Government, as of now, out of 25 High Courts, only 2 High Courts are in favor of All India Judicial Service. Out of 28 states, only 2 states are in favor of All India Judicial Service. And one reason why there is a lot of resistance against establishment of All India Judicial Service is in recruiting and appointing the judges to the lower courts, the High Court has got patronizing power. So many High Courts, they fear that they lose their patronage power once All India Judicial Service is established. So the High Courts are not willing to lose their control over appointments to lower judiciary as laid down in the Constitution in Article 233 and 234. So unless we build a consensus among all the High Courts in this country, and also by bringing consensus among the states, it's better to wait for till consensus is built. It's better to wait for establishment of All India Judicial Service. So the All India Judicial Service, if it is established by building consensus, after some time, it will definitely serve the purpose of improving the efficiency of the judiciary at the lower level. But this must be combined with better career advancement, better service conditions and a better pay. That's about the All India Judicial Service. And in addition to the Supreme Court, High Court and lower courts, in India we also have a category of courts called Lok Adalats. Lok Adalats, they are called people's courts. This is Lok Adalats. See, in 1982, for the first time, Lok Adalats were created in Gujarat. Later on, see, the idea of Lok Adalat is based on Gandhian principles. So in ancient and medieval India, we have settlement of disputes at the village level by involving the elders. So a similar mechanism is institutionalized through Lok Adalats. Lok Adalats were given statutory recognition, legal backing through Legal Services Authorities Act enacted in 1987. Under the Legal Services Authorities Act 1987, there is a provision for establishment of Lok Adalats to settle the disputes amicably between the parties. But non-compoundable offences cannot go before the Lok Adalats. And the cases which are at the pre-litigation stage, which have not yet reached the court, and the cases which are at the litigation stage, they can be taken up for arbitration through Lok Adalats. The advantage of Lok Adalats is there is no court fee. Then the lengthy procedures which are a regular feature in the ordinary courts is not required. So it is less expensive. The delivery of justice in the Lok Adalats is less expensive and it is more quick. So that's the reason why the Lok Adalats have become popular. So that's about the Lok Adalats. Lok Adalats were given legal backing by Legal Services Authorities Act, which was enacted in 1987 by the Indian Parliament. Then we also have Gram Nyayalayas. Gram Nyayalayas. So in 2008, Indian Parliament has enacted a legislation called Gram Nyayalayas Act 2008. So it is nothing but a local courts at the doorstep of the people of this country. To make justice more accessible to the people in the rural areas, the idea of Gram Nyayalayas was taken up on the recommendations of the Law Commission of India. In the Constitution of India, in the Directive Principles of State Policy, there is one article, Article 39A. Article 39A imposes a duty on the central and the state governments to make justice more accessible. So the idea of local courts is to have mobile courts at the local level to resolve the disputes of civil and criminal nature of a smaller value at the local level. That's about Gram Nyayalayas. But the Gram Nyayalayas are not working properly, and the number of Gram Nyayalayas which were set up is not up to the numbers. So initially there was a target to create a large number of Gram Nyayalayas, but only a few Gram Nyayalayas were set up. That's about Gram Nyayalayas. In addition to this, we also have the concept of tribunals. So we have Part 14A. Part 14A has inserted two articles, Article 323A, Article 323B. See, the tribunals were provided in the Indian Constitution on the recommendations of the Swaran Singh Committee by Mrs. Indira Gandhi government through the 42nd Amendment to the Indian Constitution. The 42nd Amendment to the Indian Constitution inserted Part 14A dealing with the tribunals. Article 323A deals with administrative tribunals. Article 323B deals with tribunals for other purposes. So in India we have Central Administrative Tribunal and State Administrative Tribunals. Both are set up under the law made by the Indian Parliament. If you take up the Central Administrative Tribunal, so there are certain exceptions to the Central Administrative Tribunal. So the staff of the Supreme Court and High Court, the staff of the Parliament and the state legislature, Navy, Air Force and Army, all those they don't come under the jurisdiction of the Central and State Administrative Tribunals. Then if you take the Central Administrative Tribunal, the chairman of the Central Administrative Tribunal will have a tenure of 5 years and he will retire at the age of 68 years. The members of the Central Administrative Tribunal, they will have a tenure of 5 years, but they retire at the age of 65 years. And in the Central Administrative Tribunal, the chairman shall be a serving or a retired judge of the High Court. So the chairman is appointed by the President by consulting the Chief Justice of India. So, but at the state level you have State Administrative Tribunal and at the central level you have Central Administrative Tribunal. And you can also have a joint administrative tribunal for one or more states. Even the members of the State Administrative Tribunal, including the chairman, they are appointed by the President, not by the Governor. And then there were two important cases related to tribunals. One is Sampath Kumar case. In 1987, Sampath Kumar case. In 1997, we have Chandra Kumar case, Chandra Kumar. When the Parliament has enacted the Administrative Tribunals Act 1985, initially it was provided that the decisions of the tribunals cannot be taken before the High Court under Article 226, they cannot be challenged even before the Supreme Court under Article 32. So the decision of the tribunal can be taken only before the Supreme Court, that too under Article 136. So when the matters went to the Supreme Court, in the meanwhile the Administrative Tribunals Act 1985 was amended. And this amendment provided for the decision of the tribunal can be taken before the Supreme Court both under Article 32 and also under Article 226 and also under Article 136. But a decision of the tribunal cannot be challenged before the High Court under Article 226. So in Sampath Kumar case, Sampath Kumar versus Union of India 1987 case, in this case the Supreme Court said the tribunals are equivalent to High Courts. So a decision of the tribunal need not be taken before the High Court because the tribunals are a substitute to the High Court. So a decision of the tribunal can be challenged only before the Supreme Court under Article 32, under Article 136. But later on in 1997, in Chandra Kumar case, the Supreme Court said judicial review is a basic feature of the Indian Constitution under Article 32 under Article 226, which means because of the judgment of the Chandra Kumar case, today the Supreme Court said in Chandra Kumar case the tribunals are subordinate to High Courts. They are not equivalent to High Court. They are not substitute to High Court. So a decision of the tribunal can be challenged before the division bench of the High Court under Article 226. From there the matter can be taken to the Supreme Court either under Article 32 or 226. That is the position of the tribunals today in India. So in report number 272, Law Commission of India has recommended a number of measures for strengthening the tribunals. As of now in India, there is no uniformity in terms of appointment, tenure and removal of the members of the tribunal. So Law Commission of India has recommended for uniformity in appointments, tenure and removal of the members of the tribunal. So that's it about tribunals, that's it about judiciary in India. So we have discussed about the Supreme Court, High Court, subordinate courts, Lok Adalat, Gram Nyayalayas, then tribunals and also All India Judicial Service. So we have done a thorough coverage of the entire topic of judiciary in India. That's it for today. Thank you and all the best. So we will come up with yet another topic in the next video. Thank you.